Recording. There we go. And so I am Dr. Nicole Yates. I will be I'll be moderating this discussion today. And I would like to introduce our presenters, Dave Keene and Mara Rosales. Dave Keene is the founding principal of Keene Independent. He has been a leader working in the DBE program field since 1989. He's successfully defended many of these programs in court. He's worked with state DOTs, transit agencies, and airports across the country. And in his work, he has talked with tens of thousands of DBEs and ACDBEs. And Mara Rosales is the managing partner of Rosales Law Partners LLP. She is a seasoned transportation law expert. She served as the general counsel at San Francisco International Airport prior to founding her firm. She has represented Caltrans in constitutional challenges to federal DBE regulations, and she has also represented numerous DBEs and ACDBEs throughout her career. Dave and Mara have worked together also on numerous projects, and so we're very excited to hear from them today. So for comments, we definitely invite your questions and comments throughout this presentation. So there is a Q&A function at the bottom of your screen. You should say a little button that says Q&A, where you can click that and you can enter your question or comment there. A couple of things to note: this session is being recorded and will be posted to YouTube. We are and so in the interest of keeping everyone anonymous, I will remove any identifying information if you choose to provide it in your question or comment as I read it aloud. So I'll go through, read aloud all the questions and answers that we receive there. So again, we'll have a couple of times where we'll pause for questions, and then we'll pause at the end for additional questions and comments. So with that, I will hand it over to Dave to get us started.
Well, thank you, Nicole. We want to focus on getting you all up to speed what's happening with the Federal DBE and ACDBE programs, how it may be affecting your members, and what help they may need from you and from others. And then as you advocate for DBEs and ACDBEs, what are the key issues that we see, and to get you prepared to be the best advocate possible as this program continues to evolve. So some basic background, because we think we have different people coming into this webinar today with different levels of knowledge, from some basic understanding of what these programs are to we may have some experts in the room as well. So let's talk about the history of the DBE and ACDBE programs. These are in federal regulations in different parts. So these are actually two different programs. They are congressionally mandated. They have been around for decades. The DBE program is for disadvantaged business enterprises. You put the AC in front of it, and it's for airport concessions. So just at airports. These programs are in the congressional bills that fund USDOT budgets. So the contracts that use Department of Transportation money that flows down to states and to local entities, and it may be partially funded by USDOT. If that's the case, the DBE program applies to those contracts. So a state DOT or an airport or a transit agency, when they award contracts and it uses USDOT funds, it has the DBE program attached to it, and that entity, because they receive federal funds, must be operating the Federal DBE program. Many states and many local entities also have local programs that are from monies that are not federal. And so this webinar is not about that. We can talk about that if you have questions, but we're really talking about the changes at the federal level to the federal programs. we'll be talking a lot about DBEs. We mean ACDBEs as well, all the way through. That's important. And that's a very specialized program solely related to airport concessions. So the way the programs worked prior to October 3rd, the small businesses that would meet the Small Business Administration size standards and personal net worth limits, those businesses owned by people of color and women could apply for DBE and ACDBE certification. Other firms could as well, but there would be a different application review. You are automatically presumed to be socially disadvantaged if you are a person of color or a woman based on decades of information that Congress had relied on showing evidence of discrimination based on race and gender against business owners in the transportation contracting industry. This is again prior to October 3rd. So public agencies could set goals, contract goals on those federally funded contracts, like a 10% goal or a 15% goal. And then prime contractors bidding on those contracts would either need to meet that goal or show good faith efforts that they had tried to meet that goal. And those goals would be set if that entity determined that it needed to operate that part of the federal DBE program. Not every entity or not every state was setting DBE goals on its contracts. It was only used where it was needed, where it was found to be needed. And then airport concessions worked in a similar way. So there would be a master concessionaire and there would be a goal, and as part of their sub-concessions, they would have ACDBEs involved. So that's the way the world worked. And the key here is if you're a minority women-owned firm and you were small and you were not wealthy, you could apply for the program. And based on your race, ethnicity, and gender, and meeting the other standards, you could be certified as a DBE or ACDBE. A white male-owned firm could apply for certification, but they would need to show that they were socially and economically disadvantaged on an individual basis. In most cases, if you saw 100, a DBE directory in a state with, say, 1,000 DBEs in it, there might be one non-minority, non-woman-owned DBE in there that had done that through the individual showing of social and economic disadvantage. For example, a white male-owned firm that had a disability, for example. Okay, Mara, take us through a little bit of what's happened since January 2025.
So thank you, Dave. Good afternoon or good morning, everyone. I wanted to address not just the items that are on the slide, but just give a little context before the first bullet, and that is before this IFR was promulgated by the Department of Transportation. The case law regarding the constitutionality of the Federal DBE program, specifically, not the ACDBE program, there were several cases in appellate decisions in the United States, not in the Sixth Circuit, that upheld the constitutionality of the DBE program. It's, as you know, a program that's been a congressional program that's been in place for many decades. And so, what changed with this administration? Actually, with the prior administration, there was a litigation in the Sixth Circuit, which is the Mid-America Milling case versus the Department of Transportation, where there was a challenge to the constitutionality of the DBE program. And there was, and I'm not going to get into all the case law or the legal proceedings, but bottom line is that there was a ruling. It was an interim ruling from a one judge, district court judge, that ruled that the presumption, the race and gender-based presumption, rebuttable presumptions in the program were unconstitutional. And so that case is still pending, and there's been a lot of back and forth. There have been intervening defendants, AMAC, trade organization representing DBEs and ACDBEs, entered the case, among others. And so that case is still pending in the Sixth Circuit, and there is no final decision here. But what the Department of Transportation did essentially is move from the litigation strategy, in my view, to the regulatory strategy. And so the IFR was, the Interim Final Rule was issued on October 3rd, and essentially seeks and sought, because it has not been challenged, to reach the aim of the administration by eliminating the rebuttable presumption. In the interim rule, we hear that the Sixth Circuit and the U.S. Supreme Court's case in the Harvard case in 2003 necessitated this action. Basically, the administration has taken the position that the race and gender conscious presumption in the ACDBE and DBE rules is unconstitutional. So that's where we are today. So what does that mean practically for DOTs, state DOTs, and certifying agencies around the country? Basically, the rule requires not just an elimination of the presumption, but a new system for reevaluating disadvantage, social and economic disadvantage. We're going to get into the specifics of that in subsequent slides, but as you can see here, it's a reevaluation of all certified firms and a new standard for new firms that have not yet been certified, where individuals focus on disadvantagedness, but factors other than race or gender. So state and local certifying agencies have been directed to essentially cease operations on anything that was impacted by the presumption. And it requires these last three bullets to reevaluate the certification of DBEs in their individual states, their home state, first. And then later, we can talk about this in a little bit next in a few slides. The interstate certifications are similarly treated, but separately. The home states deal with the certifications or the reevaluation of certifications first. If there are DBE goals in their DBE plans, they have to revisit those and update those. But after the reevaluation is completed, they have to also update a DBE program. And this is the same for the ACDBE program. We'll get into some of these details in subsequent slides.
Now, let me show you one or two more slides, and then we'll see if there's any questions, and then we'll talk about what's the impact and what are the to-dos for trade associations, chambers, other groups that are membership organizations of DBEs and ACDBEs, or organizations that are helping those firms. So here's the visual. So on October 3rd, it stopped all the DBE contract goals. That's a really big deal. Not every state had goals, or not every entity was using DBE contract goals, but many of the largest entities with the most contract dollars were, and that we'll see the impacts of that when we talk about the DBE survey results, but it's a big deal. The Mid-America Mailing case that Mara mentioned, in some states it already started to affect those DBE contract goals for some contracts even before then. But October 3rd was the nationwide ban on DBE contract goals until some other things had been done. And if you were a DBE on an existing contract, you had some protections still in place, but we have been hearing from DBEs that they are not secure in those contracts, and sometimes even though they were operating in good faith and the prime used them to meet a contract goal, they may not be getting the protections on those contracts that they should be getting. Okay, so that's October 3rd. And this really came out of the blue. There was no standard process for rulemaking or having comments from organizations like are attending today's meeting. We didn't get a chance to say what we thought about it. Mara didn't, DBEs and ACDBEs didn't. It was just issued and everything changed overnight. Okay, so what in each state, and this really happens on a state-by-state basis, they have been notifying DBEs of something changed, and usually there was a notification that, hey, everything's stopped, and we'll figure out what we're going to do. And they were preparing for this recertification process. What they need to do is now reevaluate the certification of any existing DBE or ACDBE in their home state. This home state is where they are certified, and then you get certified in other states based on that home state certification through a process that has not materially changed. That is still you get if you're a California firm like Mara is, you get certified in California, and then you get recertified in other states once you have that home state certification. Is typically how it works. They also need to submit overall DBE goal, a new DBE goal for their entity. So if you're an airport or transit agency, you're submitting those new overall DBE goals and a new revised updated DBE program plan. And only then can you consider restarting DBE contract goals. So we've seen this story before. In the about 20 years ago, there was litigation that affected the western part of the country. It was a case called Western States Paving. Washington State DOT lost that case in how it was applying the federal DBE program, and all goals, contract goals, stopped in about 2005, 2006 until they had done a number of things similar to this graphic, to be able to put those goals back into place. And we saw the damage that suspension of the goals did to DBEs at that time. And we may be seeing the same scenario again. So this is what's happening right now. This is a very big deal. We'll show you the DBE survey results in a moment. Any questions right now on what has just happened? And then we'll go through how the public agencies are responding and how the DBEs are responding. And if we don't have any, we'll proceed ahead.
Yep. None in the Q&A, so let's proceed ahead.
Okay, as Mara said, there is a new requirement to be certified as a DBE in a submission of what's called a personal narrative. So, as Mara mentioned, there's no longer this presumption of social disadvantage based on race or gender. The firm must show that individually and through disadvantages in education, employment, business, obtaining financing, and other things. And that applicant needs to be able to describe how that economic hardship, those barriers or denied opportunities happened in a way that they are not saying it was race discrimination or gender discrimination. Factors such as, well, maybe they were disadvantaged because they of economic situations growing up, or limited opportunities to get further education, or limited capital to start a business or to be able to expand a business, not having those types of resources compared to similarly situated non-disadvantaged business owners or individuals. So this is complicated. We pretty much summarized the key points that are in the IFR. There were two other they called them FAQs that USDOT issued that maybe added just a little bit of explanation of what this is. You don't need to hit all of these boxes if you're an applicant, but you do need to show convincingly that you have been negatively affected by social disadvantage that puts you at a competitive disadvantage to non-disadvantaged businesses. So we can answer questions about all of this. We wanted to let you know, and this could take the whole webinar, but we wanted to let you know what is happening around this. So this is pretty much the language out of the IFR. And states have individually developed certification systems for every DBE, every ACDBE gets the opportunity to recertify to stay in the program. Otherwise, if they do not hear from them, then they are decertified. Or if they submit an application that's deficient and they can't fix that, then they are decertified. So this is happening right now in most states. Some states haven't gotten started. Some states are well underway or maybe even done. Oregon would be an example of that. But summer 2026, when we talk to certifying agencies around the country, that's pretty much what we hear. And all the certifiers within the state combined form what is known as a UCP, a combined certification, unified certification program effort. And they need to work together. So a state is done when they're all done certifying, because they may split up certification duties. In a state like California, there are many, many certifiers. In a state like Oregon, there's one certifier. In Arizona, it's three certifiers. In some cases, not all of the certifiers are on board with us. Florida is an example. We understand Alabama may be an example. And so the remaining certification agencies are kind of scrambling to replace. In the case of Florida, the Florida DOT, my understanding is they are not complying with the IFR. They have asked for a waiver to just do away with that program and do something else. And so other certifying agencies in the state are trying to pick up the slack to be able to certify DBEs and ACDBEs in Florida and comply with the IFR. So that's what's going on around the country. When they accept certifications, how do you write a personal narrative that tells your personal story without mentioning who you are and all aspects of who you are? That's a good question. Many of the states that we've talked with and certifying agencies allow the owner to mention race and gender, but they can't base the decision noting the information in the IFR, the directive in the IFR, that they can't base their decision on the race or gender of the business owner. So the interpretation of that is, for many states, is please give us a reason to certify you other than race or gender. And you can mention race or gender, but there needs to be something that we can make a base a certification decision on. Now, Mara and Mara with who is an attorney who has the qualifications to do this, and me as a layperson can think about any prohibitions on mentioning or even using evidence of race and gender discrimination, to say, hey, I'm socially disadvantaged. That may be the basis of their social disadvantage. And for a government rule to come out and say, no, you can't do that, it would seem to be problematic. But that's what's happened. And to our knowledge, there's been no litigation around the IFR. So it's the law of the land today. And DBEs and ACDBEs around the country are applying through these systems. So the most straightforward is I can mention who I am, and but I need to mention social disadvantage and give my evidence of that, not based on the race or gender. And some states are not allowing the mention of race or gender, and they'll just send it back. So if you say, I'm a woman of color and I'm this business owner, just saying that gets you your personal narrative sent back. And we're using PN in this slide as a shorthand for that. And then you got to fix it. Some are not even mentioning not allowing mention of words that could be interpreted as gendered or race or ethnicity, like the word mother or daughter or wife. And if you use that in some states with some certifiers, it's sent back, and you gotta exercise that from your personal narrative. It's a strange world that we live in, but that's what's happening. Again, we have opinions about this, but we wanted to let you all know what's going on, and you can probably imagine what our opinions about this are. Okay, allowing revisions to personal narratives. There's the possibility that you put in your personal narrative is either unconvincing, or you're in one of those, you're applying to one of the public agencies and certifiers that don't allow you to use these race or gender terms. They could deny your certification, and then you'd be automatically out. What we're finding instead is those states are allowing the DBEs and ACDBEs applying for recertification to fix their certifications or cure their applications. That may not be always the case, but in general, that seems to be the case. And that's good to know, because if you don't get it right the first time, you might have an opportunity to have a next crack at it before you're decertified. And then finally, how well are they doing? When we saw the IFR come out on October 3rd, Mara and I were very worried that many DBEs would not go through the process of reapplying, because it just looked difficult or impossible, and there was very little instructions on how to reapply, very little instruction from USDOT to those certifiers on how to operate this new concept. Keen Independent, our team did a pilot of how to put personal narratives together, and we worked in Arizona with about a dozen DBEs, and to see if you could actually do this. And we found that you could, and not mention race or gender as the reason for your social disadvantage. But what we found from those DBEs is they told us that they would not have been able to do that without any help, and weren't going to do it in many cases without any help. And that's what we found. So those states that are the furthest ahead in the recertification process, only about half of the home state DBEs and ACDBEs have applied for certification and been approved. And that's just a handful. At this time, at this moment in time, we think across the country, that's more like 10%. So 9 out of 10 DBEs that have, many have relied on this program to even be contacted for opportunities on federally funded contracts. This program doesn't guarantee work. It just guarantees the opportunity to compete for that work as a subcontractor in many cases. Most of those firms were not going to reapply and have not reapplied. So we are seeing about a 10% in most states have applied. We hope that's wrong. We hope that's higher by the end, that we may be early in this process for some states. That's very disturbing and concerning. And one of the reasons we want to have this webinar with chambers, trade associations, and other groups that support DBEs, because that's a big problem. This program may not work at all if you only have a few DBEs in a state that have gotten through the recertification process. Now, the IFR in the fine print, in a footnote to the fine print, anticipated that 90% of the DBEs in a state would reapply. So nobody's reaching that. And we don't see anybody even attempting, any states and certifiers even attempting to get that to that level. That would require providing individual assistance to DBEs, and we see a little bit of that happening, but not a lot of that happening. We hope this information is valuable to you. This is a 4-alarm fire, and you all still have time where you can do some things that help us. Okay, before we get into our survey to hear from DBEs, any questions on the previous slides we just showed you?
Yes, we did have one question in the Q&A that I'll read. Will the Federal DBE DOT program include people with disabilities versus just state-run DOT contracts?
So under pre-October 3rd and post-October 3rd, persons with disabilities always had the opportunity to apply for DBE certification. And we saw some businesses owned by people with disabilities in the program. There's no automatic presumption of disadvantage based on disability. That wasn't in the pre-October 3rd rules, and it's not in the post-October 3rd rules. Those firms would need to apply and show social disadvantage because of that disability. The big difference is that is allowable to talk about. You can't talk about race in some states. You can't talk about gender in some states, but those prohibitions on speech do not apply to disability. so you can confidently write a personal narrative explaining how that has led to social and economic disadvantage, using the word disability, explaining in detail what your experiences are, and not being punished for that or not being disapproved for that. That puts you perhaps in a different situation than a business owner of color or a woman business owner.
Thank you, Dave. Let's move on.
Okay, real quick. How have DBEs been affected by this? We did a survey, national survey, 165 DBEs and ACDBEs took the time to give us their input, answer our questions, and have their voices be heard. This is not every state across the country, but most of them. And we had professional services firms, construction firms, other types of firms, big and small, answer this survey. When we asked what type of assistance in your state or by your certifiers was offered related to this recertification, most of them said nothing or just the bare minimum of a written notification. So this has been a major complaint of DBEs from the beginning, is they're not getting the information because this was just invented. This new way of showing disadvantage through a personal narrative with the prohibition of it having to be based on race or gender. So this isn't for the DBE. This doesn't make a whole lot of sense. This is a very different application process than you've been successful with before, and what the certifiers have done is according to the DBEs is really dropped the ball. At least most of them have. So about a quarter say, hey, we've had workshops, written guidance, maybe some examples, other assistance. Only 1% that they had identified that one-on-one assistance was available. We think that that was critical to this process and very disappointed that that's only 1%. So this is evidence that DBEs are not being supported by the state and local public agencies that have supported them in the past. They've provided some of this assistance, even one-on-one assistance, as firms became certified in past years. But in response to the AFR, it has been very lacking, and it's especially damaging because of how confusing and how counterintuitive all of this is. We ask are you satisfied? Are you dissatisfied? 75% of the DBEs said either there was none to be satisfied or dissatisfied with in terms of assistance, or they were dissatisfied with the assistance that was available. And some of the comments that we got, many of the DBEs that were responding to the survey gave us comments about this. They said, yes, just no explanation, no information. Sometimes it's just been radio silence. You see something that's printed, you can't get a hold of anybody, nobody will answer any questions. Just complete lack of communication. And we think this last comment is very illuminating and troubling. This process has been humiliating. What the process, in my mind, asks you to do is tell a very personal, very emotional, and difficult story about how you have been affected by disadvantage throughout your life. It may start as a teenager, and going through your personal experience and what disadvantages you may have faced compared to others. When we did our pilot program, we had tears in our personal narrative sessions and tears among our team afterwards, because it was very these were tough things to help people with. The stories were that powerful, and getting it on paper was our big contribution to this. People could tell their story, but we were able to get it on paper for them. And we were distraught after doing that. When we talked to certifiers around the country, we were hearing the same thing. So it's that charged, it's that emotional, it's that you need to go through that kind of process. And on the other side, you have this cold, faceless public bureaucracy that's not giving you any information, any feedback in many cases, not always. And that's a dichotomy that's very, very troubling and very disturbing. So that's just one of the comments that we got, but there are many others about the, uh, what a difficult time this is for DBEs and having to be put through this. When we asked what kind of help would be useful, 44% of the survey respondents pointed to personal help on my personal narrative. You also need to do a personal net worth statement. This is complicated. It's much more than, hey, just submit a tax return, which would go to the size of the business. This is the assets and net worth of the business owner or multiple owners. It can be very complicated. Only 16% said they needed help on that. They've done that before. And for most DBEs, this is not anything you want to do, but it's not a new thing in that they didn't really change the rules on this. It's the same process as before. So comments, it'd been nice if states offered this assistance on personal narratives. Samples would have been great. Clearer guidance and procedures. All of this that in their state was not done. And finally, has this affected you? Has it affected your business from the prohibition on DBE contract goals? 57% said yes, a negative effect on my opportunities. Again, this program is no guarantee of work. It's just providing opportunities to be able to bid on work. They said, I stopped getting calls. So we'll see some of the comments in a minute. Another portion said, the program wasn't really working for me anyway. So I wasn't getting work on these contracts. So really 3/4 of the answers here were negative. 15% said things are fine, no effects since my firm wins work without the goals. And then we got comments about not seeing contracts. Some of the states and local agencies are holding back on federally funded contracts and just simply not issuing them for bid until they get this sorted out. So that is a negative. We see this? My business has suffered tremendously. Primes stop calling, or primes are actually predatory, which is the gist of the third comment on this slide, as well as the fourth comment, which is, hey, I had work, but the prime contractor just kicked me out of the project. Not supposed to happen, but apparently is happening. And then some of them quantified the economic damage on their firm, lost $1 million in revenues, or losing opportunities for concessions. Okay, so we skimmed over this. We tried to hit the highlights of what we learned from the survey. And let me go through this last slide, get Mara's comments on it, and then open it up for questions. So our advice to DBEs, ACDBEs, and those that are supporting them, including people on the call today, DBEs and ACDBEs should recertify. This was what this is all about. Only a few are. When you attempt to recertify, you will need to submit a personal narrative, tell your story, and ensure in your story that the certifier can make a decision on social disadvantage, not based on the gender or the race of the business owner. So if being rural is a problem, mentioned disability before, having a disability is a problem, taking care of others with disabilities could perhaps put somebody at a disadvantage. Economic disadvantages that led to social disadvantages, not being in the networks. We heard many other types of disadvantage when we did our work and when we talked to certifiers. There's many stories out there, and these stories are being told by people of color and women that own these businesses, and they're telling the parts of their story or emphasizing the parts of their story that don't have anything to do with their gender or their race. And you need to respect the rules of the certifier. If they say you can't mention race or gender, it's going to be hard to do, but don't mention race or gender. Seek assistance if you need it. For those groups that are supporting DBEs, figure out a way to get them assistance because they do need it. We offer that assistance. Other firms like us offer that assistance. Rosales offers that assistance. Sometimes that's there are networks within a state that are doing this. In many cases, they're not. But you may need to get some expertise yourselves to be able to offer it. But it's definitely needed because it's very hard for the individual when you're trying to tell the story. You have a blank page to figure out what needs to be on that page to fill it out with your personal story. That's the biggest barrier is the blank page problem. And even just listening to somebody and writing down their story can be helpful. Because the DBEs are negatively affected, the longer this goes without DBE contract goals, the bigger the damage. Most states are not moving quickly. So as advocacy organizations, if we have those on the call today, our message would be this is doing damage to DBEs and it's doing more and more damage the longer this goes. And summer 2026, to get through a recertification and maybe the end of the year to be able to get to back to DBE contract goals. Some of these firms may be permanently damaged to the point where it's going to be very difficult to recover. And we saw firms go out of business. We have lots of data on firms going out of business because of not being DBE certified or not having DBE contract goals. It really negatively affects those firms. Time is the enemy here. I think this is a good place to stop and ask for questions or other comments. And Namara, I wanted you, as people are writing those in, I wanted you to be able to weigh in on recommendations as well.
So thank you, Dave. One thing that I would add is as supporting groups or advocacy groups or obviously chambers, there is a role as stakeholders to play here. In my experience, and now 3+ decades in this field, the trade organizations or the community-based organizations are instrumental, not just in providing information, networking, but in essentially assisting. In this case, there's a role, I think, here that would be helpful to consider, helping perhaps do focus groups or workshops on personal narratives. I think there's an interest there, given the results that we've seen. If there's any, if you will, leverage that a trade organization and or a community-based organization has with the governmental entity that's doing the certification or implementing the program, I think that's a fantastic connection to have and to seek collaboration. I also sense that some of these certifiers throughout the country are a bit at a loss on how to proceed based on the questions we've received. And the USDOT, from what I can see, has not been as helpful as I would expect them to be or as they have been in the past. So I would encourage everyone to consider kind of a proactive role to play here to move this needle, if you will, along so this program can be implemented in as many states as possible, as quickly as possible.
Thank you, Mara. We do not have any open questions. Again, folks, if you all want to type in your questions into that Q&A, I can read them aloud. But in the meantime, I will go over next steps following this webinar. So we will send you a follow-up email that'll contain a YouTube link so you can view this presentation at any time. Please feel free to share this with your networks. You can also keep up with us with Keen Independent on our LinkedIn and on our company website. We've got links there on the screen on the right. And we also provide support for personal narrative drafting to DBEs and ACDBEs, so we can also be contacted for those services. It looks like we don't have any additional questions in the Q&A, so let me hand this over to Dave and Mara to wrap us up. Thank you.
That's great. We hope you found the information in this webinar to be useful, and please feel free to share it. We did a kind of a sister webinar last week with DBEs and ACDBEs, and that's available on our website as well. And that has more information about the personal narrative process, which we didn't have time to cover in detail today. And please reach out to us if you have questions. Mara?
Well said. Thank you for your attention, and certainly any questions, any follow-up questions that you think of later, feel free to contact us. Thank you.
Thank you, everyone.
Is there?
Take- Oh,
Nope.
yep, there is. Nope, there's a question real quick before we before we adjourn. There was a question. What is the average cost for the DBE personal narrative prep?
The costs can vary when we kind of look at the services around the country. We've seen it in the thousands, maybe up to 5,000. That's, we are doing this at a much lower cost. And Mara, I don't know what perspectives you have on this.
Yes, I think that just like any new regulatory program, everyone who tackles a personal narrative in terms of a professional who's providing advice, you want to make sure that you cross the T's and dot the I's, and I think that's why the cost tends to be on the higher end. And of course, it depends on the personal experience that's being told and how detailed it is and how much back and forth it is. But yeah, just speaking for my own firm, of course, we're attorneys, so attorneys, of course, tend to be more expensive than other consultants. I would say yes, it's right now, I would say between $2,000 and $4,000.
Thanks, Mara and Dave.
And the final word on that is it depends, because it may be fairly straightforward, and
Yes.
your situation may be more complex. Especially if you have multiple owners, it may be more straightforward. It might be a little bit cheaper, even than what Mara mentioned. I would say this is so important that these are the types of costs that you weren't planning on having to pay, but may be well worth it. And it may be much more efficient because your time is valuable too. If you can just get a personal narrative in and you don't have the back and forth with the certifier, it's just accepted, then you've saved, that's a net win for everybody. We really appreciate everybody attending. We want to make sure you know that there's an open door from both Mara and Keen Independent. So we hope to be hearing from you.
Thank you all very much. Look out for those follow-up emails, and please do respond with any questions or comments. Thank you for being here this afternoon, and have a wonderful rest of your day.
Thank you.